Hello, I'm attorney Dan Marr in the national law firm of Hamlin Kerrigan, and I've been practicing law 36 years in New Hampshire and 28 years in Massachusetts, and during that period of time I've been involved in a lot of trust and estates disputes, basically arguments where the relatives or people that care about somebody who passed on are having a dispute as to how the inheritance is given. Maybe it was what's called inter vivos gifts during their lifetime of the person, or gifts upon death through a will or a trust. And there's arguments as to whether or not the person had the mental capacity to deal with it or undue influence. And I'm going to explain those concepts. I've litigated those cases both in the Commonwealth and Massachusetts and in New Hampshire, as well as resolve cases and help people resolve them in the early stages and therefore avoiding litigation, and then sometimes before the trial happens. And I've also tried the cases and gone up to the Supreme Court. I'm going to talk today about a matter that I had quite a few years ago. We had a 5.5-day trial. Went up to the New Hampshire Supreme Court. The whole case went up. I was successful in it, defending against an undue influence claim. But I want to go through the logistics of that case because it's helpful for to understand how these cases go out. In that situation, there was a elderly gentleman who he and his wife had lived together for many years, good, strong marriage. They had 2 children together, and she got a serious illness. They sold their condo, moved into an assisted living where there was a staged assisted living where he lived in one of the apartments because he was fully ambulatory and fully mentally competent, and his wife had to go immediately into the serious care that was dealt with for somebody that had the serious situation that she had. She only lasted for a few weeks and passed away. During the period of time that he was there, he got involved with one of the staff members at the assisted living. Now that's a whole conflict issue with the staff. That's a separate issue. But they ultimately moved out of the facility. She moved from her apartment, and he moved, and they moved into a 55 over community. The daughter, who lived in the next town over, said that they were having romantic relationships. She denied it, but the caretaker, but they were 20 years difference. He was in his 80s, she was in her 60s. And there was a lot of bad feelings from the daughter in regards to him getting a relationship that early on after his spouse died. And during the whole period of time during the litigation, after he passed away, she sued, and I defended because he actually came to our firm. He had done estate planning with our firm, and he said to us, protect her, protect his 20-something year younger caregiver. He said that my daughter's going to come after you, and I want you to protect. And we did, and we successfully protected her in regards to right through litigation and a case up to the New Hampshire Supreme Court. So we followed his advice, and it was a good result. But during that whole period of time, she was arguing that this was a family inheritance. And first I wanted to start off with the proposition that there is no family inheritance unless the estate planning says so. People can make their own decisions as long as they're mentally competent and they're not subject to undue influence. Mental competency is you don't know who your children are, you don't know generally what your assets are, you don't need to know down to the dollars and cents, but you have a general idea of what your assets are. You don't maybe even know who the president is, and it's not a matter of politics where you don't agree with that president is your president. It's a matter of, so it's not humor or strong political beliefs. It's actually not knowing what's going on in current events in general terms. That can lead to mental incompetency. Undue influence, you can sometimes have a diminished capacity and be subject to undue influence. Undue influence is usurping that person's free will when they don't really even know. They're not making the decisions themselves. Maybe it's a threat saying you're going to go to a nursing home if you're not with me. Lying about their assets, saying they don't have any assets, and having them sign stuff, isolating them from other people, so that they don't have the opportunity to see other people and get out. So it's that person is their whole focus. Those types of elements, I've litigated these things quite a bit, that can get to an undue influence situation. In this particular case, I pointed out that the daughter was in the next town over in New Hampshire, and she could very easily come over and visit them, but she didn't want to because she was uncomfortable with him being in a relationship, whether it was platonic or romantic, with this 20-something year younger person, and she didn't like her. So she didn't see her dad. She didn't spend the time. And there was quite a bit of evidence in this 55 over community that he felt she wrote me off, I'm writing her off. There was a son who wasn't involved at all. He was just completely off the radar. He wasn't paying attention. Just I don't know why, but he wasn't paying attention, so he wasn't in the picture. But she fought this. And one of the things that I also did is she had her own expert. We didn't have our own expert. They had a psychiatry expert. I just attacked her expert. I effectively attacked her expert with cross-examination based upon other testimony that he had elicited in other cases that I got. Plus, I got what was going on in the community. 55 older community, wonderfully. She had a dog, so they got out and about. And I spent the time to talk to the neighbors and find out everything, right down to the issues of the daughter said he doesn't, they go out to eat all the time, and the neighbor said she could burn water. She was a horrible cook, and that's why they went out to eat. And also he spent some more money, and there was some issues. The judge went and said in the decision in our favor that maybe he had a realization of his sense of that his life might be over in a little while, and he might as well enjoy some of his life while he's there. So all of that stuff worked out. We had a 5.5-day trial, 5 days, and then about half a day worth of video depositions. We went to the Supreme Court when we won. We won in the first instance. We went to the Supreme Court agreed with us too. But in that case, that's a good fixture of that. I can talk to anybody that you're in a situation like that. Ask for me directly. I'm happy to talk if you call our firm. There's an intake process. We can go through our legal assistance to check with conflicts, but if you ask specifically for me, it will get to me after that conflict system, and I'm happy to talk through and I can answer further questions in regards to that. My name is Dan Marr. I'm at 603-883-5501. Attorney Dan Marr. Call me Dan. M-A-R-R. 603-883-5501. Check out our website, NashwaLaw.com. That's all one word, .com. And my weekly vlogs are there. I did a radio show from December 2014 to March of 2023 weekly. That's in there too. So please take a time to look at that if you're interested in this issue of undue influence, mental competency on either side of the matter, because I've dealt with both cases, both situations successfully in both negotiating and litigating. And give me a call. I look forward to working with you if the opportunity arises. Thank you.